So now we're into these two interesting stories, and we're going to get to the story of the judge, the Department of Justice wanting to drop the case against Michael Flynn, and this judge saying, I don't know if I'm going to let you. We'll get to that in a second. Let's get now to the unmasking, because your article at National Review, the real story is when Flynn was not masked in the first place. When I heard about the unmasking, we learned that it was the U.S. ambassador to the UN, Samantha Power. It was Vice President Joe Biden. It was Comey. It was the CIA director at the time, John Brennan. The director of national intelligence at the time, James Clapper. Dennis McDonough, who was the chief of staff to President Obama. All requested unmaskings having to do with Michael Flynn. And what was the purpose of all of these unmaskings? What you noted, being a lawyer, a former assistant attorney there in the Southern District of New York, what you noted is that of everything that was unmasked, Michael Flynn, in the conversation with the Russian ambassador, was the one thing that was never asked about being unmasked. So when we learned that Barack Obama knew that Michael Flynn had a conversation with the Russian ambassador, when Sally Yates, the acting attorney general, found that out, she was stunned that the president would know this. What you noted was that if this is the case, if we go through all this information, Flynn was never unmasked in the conversation they claim is the problem. So therefore, how in the world do they know it was Flynn?
Yeah, that's right. The only way this is explainable is if he was never masked in the first place, which is what I think happened. And you're quite right that what we've seen in the last, what was put out by Director of National Intelligence Grinnell, is that from November 8th, the day that Trump won the election, until the end of January, Flynn was unmasked by 39 different Obama administration officials on 53 different occasions, which is an extraordinary number of unmaskings in a short period of time. And mind you, we're only talking about one official. We know that the unmaskings the Obama administration did were much broader. But my point was the whole thing driving this train is the Kislyak conversation. That occurs on December 29th. And according to the unmasking records we got, there's an unmasking of Flynn on December 28th, the day before the conversation. And there's not another one until January 5th, even though we know that by January 3rd, they were already talking about Flynn having this conversation with Kislyak at very high levels of the Obama administration. Therefore, this cannot have been an unmasking. And I sense that it had to have been a situation where Flynn was never masked in the first place, and this conversation was intercepted by a program, an intelligence program, that doesn't require masking or unmasking. That is outside the FISA, outside the NSA normal rules, probably by the CIA or a foreign intelligence service.
So the masking happens when an American citizen is involved in a conversation with a foreign suspect, right? And so because they're American citizens, they're protected. So you would have to unmask them, unveil their name if you were a high-level official with certain levels of security clearance to see if that person was connected to maybe other things an investigation was dealing with. But in this case, as you describe it, there was no actual unmasking, which would mean it probably wasn't under the purview of the FBI or anything on American soil.
Yeah, that's right. The masking is done in connection with intelligence programs that take place under FISA, which is the Foreign Intelligence Surveillance Act. The CIA is not regulated by FISA. It's regulated by a longstanding executive order that's been modified a number of times, but it goes back to President Reagan. And they're just not under the same rules. And obviously, neither are intelligence services that aren't under American law.
So I want to understand you when you go through this and you break this down. What you're saying to me is that our intelligence services were keeping an eye on the incoming national security advisor because they didn't trust him or they were looking for something on him. That's what it sounds to me like you're saying.
Yeah, and what I'm saying is more probably broadly argued in Ball Collusion, which you were kind enough to mention before. And that is that I think this investigation goes back to 2015, and it involved a lot more than the FBI. I mean, we've heard a lot about once they opened their investigation in July of 2016 and the FISA surveillance warrants and Carter Page and all that stuff. I think the CIA played a key role in this more sweeping investigation than people have realized it was, and that it goes back considerably before what we've been concentrating on.
Talking to Andrew McCarthy. That book, by the way, is called Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. Find it at Amazon.com. Senior fellow at the National Review Institute, and also spent time in the Southern District of New York as an assistant attorney. I want to now, so that's the unmasking conversation, and we're going to learn more about this as more information comes out. I don't think there are people like yourself and others digging in. Sidney Powell, who is now Michael Flynn's lawyer, who is going to keep working to get this case dismissed and keep digging on this. The conversation about the judge becomes fascinating. The Department of Justice says, you know what? We don't have a case here. We want to drop the case. The judge in this case, Judge Sullivan, says, I'm not so sure we should drop this case, then turns to another judge, a retired federal judge by the name of John Gleeson, and says, hey, why don't you make a case for why this case should continue? File the brief, an amicus brief, on why this case should continue. Since when does a judge hear from the Justice Department that, hey, we don't want to move forward on a prosecution, and say, well, we're not so sure that we want to listen to you, Department of Justice, even though you're the one who filed the case. We're going to see if there's reason to continue this case.
Yeah, that's not supposed to happen. The only
okay, as long as I got that part right, we're good.
Yeah, right. Well, the only component in the government that has the power to prosecute, to decide whether to prosecute, to continue to prosecute, is the executive branch. In our system, that's an executive responsibility. And judges can squawk if they don't think prosecutors should dismiss cases. They can say, I think you're going too soft on them. They can say all kinds of stuff, but they can't do anything about it. It's not the judge's job to decide who gets prosecuted. The unfortunate thing, Tony, is there's kind of a tension between the statute that is in place. The rule of evidence, or the rule of criminal procedure, says that when the government moves to dismiss charges, it's got to be done with the leave of the court. That's probably unconstitutional, but Congress put it in to protect the defendant, not to give the judge a second guess on whether the prosecutor should actually drop the case. The idea was, prosecutors can do a lot of abusive things, like they can dismiss a case when it's not going well and figure they'll indict it later, or they can indict it and dismiss it, indict it and dismiss it to try to wear down your resources to resist the prosecution. There's all kinds of shady things that could be done, and that provision in the rule is designed to prevent that kind of stuff from happening. It's not designed to give the judge the power to tell the prosecutor that they can't dismiss the case for the benefit of the defendant. And I think Judge Sullivan here has seemed to forget that the role of the United States courts is to protect the defendant from overbearing conduct by the executive branch. It's not to oppose the defendant and invite a bunch of amicus, amateur prosecutors to come in and oppose them too.